The National Green Tribunal has been established on 18 October 2010 under the National Green Tribunal Act 2010 for effective and expeditious disposal of cases relating to environmental protection and conservation of forests and other natural resources, including enforcement of any legal right relating to environment and giving relief and compensation for damages to persons and property and for matters connected therewith or incidental thereto. It is a specialized body equipped with the necessary expertise to handle environmental disputes involving multidisciplinary issues. The tribunal shall not be bound by the procedure laid down under the Code of Civil Procedure 1908, but shall be guided by principles of natural justice. The tribunal's dedicated jurisdiction in environmental matters shall provide speedy environmental justice and help reduce the burden of litigation in the higher courts. The tribunal is mandated to make an endeavour for disposal of applications or appeals finally within 6 months of filing of the same. Initially, the NGT is proposed to be set up at 5 places of sittings and will follow circuit procedure for making itself more accessible. New Delhi is the principal place of sitting of the tribunal, and Bhopal, Pune, Kolkata and Chennai shall be the other 4 places of sitting of the tribunal. The National Green Tribunal Act 2010 under Section 19 gives the tribunal power to regulate its own procedure. Additionally, the tribunal is not bound by procedure under the Code of Civil Procedure 1908 or the Indian Evidence Act 1872 and is guided by principles of natural justice. However, the tribunal is vested with the powers of a civil court under the Code of Civil Procedure for discharging its functions. The tribunal has formed its own rules since applications to the tribunal are inherently distinct from civil suits or writ petitions. The tribunal identifies necessary parties as required under necessary statutes mentioned in Schedule 1 of the NGT Act 2010 and requires them to promptly respond by email, which saves time and cost. Notice is not issued mechanically to every party named as respondents in the application. The tribunal entertains letter petitions, which brings light to instances of substantial environmental damage. A valid complaint is taken note of even in the absence of any representation from the aggrieved party, and response is sought by email and can be filed even without an advocate. Further directions to submit factual and action taken report are issued to identified statutory authorities and or experts identified by the tribunal as deemed appropriate to investigate the claims of environmental damage. An executable order is passed requiring concerned authority to take steps including restricting pollution, recovering compensation, and initiating prosecution. Upon adjudication of claims by the tribunal, select members or committees, including those comprising former High Court judges, former chief secretaries, or subject matter experts, may be appointed to ensure timely execution of the orders in cases where it is deemed appropriate by the tribunal. Expeditious decision making is beneficial not only to litigants but also enables prevention of potential environmental damage instead of compensating for damage already caused. By serving the orders and seeking responses by email only saves time and enables the tribunal to take decision in a time-bound manner. In the absence of full strength of judicial and expert members in regional benches of the tribunal situated in Chennai, Pune, Bhopal and Kolkata, the principal bench in New Delhi is hearing applications from other jurisdictions remotely by video conferencing to meet the needs of the litigants. National Green Tribunal has been bestowed with powers to decide on questions for implementing laws mentioned in Schedule 1 of the NGT Act and to be heard on all cases which are civil in nature and deals with environmental issues as follows. The Water Prevention and Control of Pollution Act 1974, the Water Prevention and Control of Pollution Cess Act 1977, the Forest Conservation Act 1980, the Air Prevention and Control of Pollution Act 1981, the Environment Protection Act 1986, the Public Liability Insurance Act 1991, the Biological Diversity Act 2002. National Green Tribunal handles every violation related to above laws or any government decisions or order covered under above laws. However, Indian Forest Act 1927, the Wildlife Protection Act 1972, Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006, and any other laws made by states which are related to protection of trees, forests, etc. have been kept out of NGT's jurisdiction. This restricts the jurisdiction area of NGT and at times hampers its functioning as crucial forest rights issues is linked directly to environment. A National Green Tribunal order can be reviewed as per Rule 22 of the National Green Tribunal Rules. An order of the tribunal can also be challenged within 90 days of the same before the Supreme Court if the review petition before tribunal fails. In October 2021, the Supreme Court declared the National Green Tribunal's position as a unique forum endowed with suo motu powers to take up environmental issues across the country. As per Supreme Court, the role of the NGT is not simply adjudicatory in nature. It has to perform equally vital roles that are preventive, ameliorative, or remedial in nature. Over the years, NGT has emerged as a critical player in environmental regulation, passing strict orders on issues ranging from pollution to deforestation to waste management. NGT offers a path for the evolution of environmental jurisprudence by setting up an alternative dispute resolution mechanism. It helps reduce the burden of litigation in the higher courts on environmental matters. NGT is less formal, less expensive, and faster way of resolving environment-related disputes. It plays a crucial role in curbing environment-damaging activities. The chairperson and members are not eligible for reappointment. Hence, they are likely to deliver judgments independently without succumbing to pressure from any quarter. The NGT has been instrumental in ensuring that the environment impact assessment process is strictly observed. In 2012, POSCO, a South Korean steelmaker company, signed a MOU with the Odisha government to set up steel project. NGT suspended order and this was considered a radical step in favor of the local communities and forests. In 2012, Almitra H. Patel vs. Union of India case, NGT gave judgment of complete prohibition on open burning of waste on lands, including landfills, regarded as the one of the most important case dealing with the issue of solid waste management in India. In 2013, in Uttarakhand floods case, the Alaknanda Hydropower Company Limited was ordered to compensate to the petitioner. Here, the NGT directly relied on the principle of polluter pays. In the Save Mon Federation vs. Union of India case 2013, the NGT suspended a 6,400 crore hydro project to save the habitat of a bird. In 2015, the NGT ordered that all diesel vehicles over 10 years old will not be permitted to ply in Delhi NCR. A December 2016 amendment to Environmental Impact Assessment 2006 notification. The amendments basically sought to give local authorities powers to grant environmental clearance to builders, was nullified by the NGT, terming it as a ploy by the government to circumvent the 2006 rules. In 2017, the Art of Living Festival on Yamuna floodplain was declared violating the environmental norms. The NGT panel imposed a penalty of Rs 5 crore. The NGT in 2017 imposed an interim ban on plastic bags of less than 50 micron thickness in Delhi because they were causing animal deaths, clogging sewers and harming the environment. If you enjoyed this video, then please like and share this video, do subscribe to the channel and don't forget to click the bell icon.